Apologies for the tardiness. Many things went wrong this morning. Sorry about that. Good morning. My name is Christian Lotta. I'm chair of the CPC committee and secretary treasurer of the board. We are about to begin the July 25th, 2024 Committee on Professional Conduct meetings. So let's begin. The CBA has provided the opportunity for the public to participate via the WebEx platform. When we take public comments, we will begin by taking public comment from those individuals attending the meeting at the Sacramento location. I will then ask the moderator to open up the lines for public comment. You will be allotted up to 5 minutes for public comment. And I would like to note that CBA member Jacobson is not participating via WebEx. Apologies. That's from a previous meeting. So we are pleased to have Mr. Jacobson here today in Sacramento. Ms. Reed, I would like to establish a quorum.
Doug Aguilar, Dan Jacobson,
Here.
Christian Lotta,
Is it?
Teresa Thompson,
Present.
and Yin Tu.
Here.
We have a quorum.
Thank you, Ms. Reed. I will now read our mission statement into record. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Now we can begin with our first agenda item, which is public comments for items not on the agenda. Do we have any public comments from our committee member, from our public here in Sacramento? Seeing none, moderator, please open for public comment on WebEx.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing none, would you like me to close the Q&A feature?
Yes, thank you, moderator. That concludes our item number 1. We can continue to agenda item number 2, approve minutes of the May 16th, 2024 Committee on Professional Conduct meeting. Do I have any committee comments?
Oh, I was going to make a motion to approve.
Okay, do I have a second?
I'd be happy to second that.
Thank you, Mr. Jacobson. Do we have any public comment here in Sacramento? Seeing none, moderator, please open WebEx for public comment on agenda item 2.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Thank you, moderator. Ms. Reed, please take the vote.
Doug Aguilar,
Abstain as I wasn't present. Sorry.
Dan Jacobson,
Yes.
Christian Lotta,
Yes.
Teresa Thompson,
Yes.
and Yin Tu.
Yes.
The motion carries.
Thank you, Ms. Reed. Moving on to agenda item number 3, discussion and possible action regarding certified public accountant firms and alternative practice structures. We will have a presentation by Ms. Carrie O'Connor, our Chief of the Enforcement Unit. I'll turn it over to you now. Thank you.
Thank you, Chair Lotta. My name is Carrie O'Connor, and I am the Enforcement Chief. The purpose of this agenda item is to provide the CBA with information regarding CPA firms with an alternative practice structure, also known as an APS model. For this item, the APS models to be discussed are firms with an employee stock ownership plan, known as an ESOP, and firms with a private equity PE ownership. This topic is brought forth today as over the past few years, we have seen a national trend in CPA firms transitioning to an APS model. Both of these structures are permitted in California, so long as they follow certain requirements that I will discuss later in my presentation. First, I'd like to start with some general information about CPA firms licensed in California. CPA firms licensed in California can be formed as either partnerships, either general partnerships or limited liability partnerships, or accountancy corporations. Generally, firms are owned in whole by licensed CPAs, although California does provide for non-licensee owners subject to certain terms and conditions, as noted in Attachment 1 and highlighted on the bottom of page 2 to the top of page 3 of the agenda item. Next, I'd like to highlight some pertinent information regarding firms operating under the ESOP ownership model, which is the less complex structure of the two. Under an ESOP, employees own part or all of the company they work for. In this model, employers have the option of either replacing workers' traditional 401ks with an ESOP or including it as an additional employee benefit on top of an already existing retirement plan. An ESOP's assets are required to be held in a trust, which is a separate legal entity from the employer. Some states do not allow for an ESOP ownership model. However, this is permitted in California, as non-licensee owners are not required to be a natural person. To operate under this model, California CPA firms must be licensed as an accountancy corporation with the CBA and follow CBA laws and regulations, such as providing the CBA with an updated list of shareholders. Now moving on to the private equity or PE ownership model. PE ownership is an alternative practice structure where firms partly owned by private equity split the firm into two organizations. The former organization continues to exist and is the entity that is licensed by the CBA, with a majority of CPAs making up the ownership. This entity performs the attestation services. The newly formed entity provides non-attestation services and may not hold out as a CPA firm. Non-licensee employees are to be engaged only in services offered by the newly formed entity, such as tax advisory services or consulting. The new entity does not have the same restrictions for CPA ownership. There are potential risks for this model. One being that consumer protection could be jeopardized by prioritizing profits over quality and public trust. Another could be that firms need to comply with Business and Professions Code 5079 related to a PE materially participating in the operations of the CPA firm, and also ensuring that the firms are adhering to independence rules. It is the firm's responsibility to ensure that they comply with these requirements, and CPA firms operating as an APS must examine the independence rules to monitor that their firm is in compliance and that the CPA firm and non-CPA entity do not hold themselves out to the public in a manner that does not cause confusion. With the APS being a new trend, and with issues relating to consumer protection and independence rules, there may be a need to explore whether a change to the Uniform Accountancy Act, UAA, is necessary. Staff recommends that the CBA send a communication to NASBA, provided an attachment 2, requesting that this emerging trend be evaluated further, including whether possible changes to the UAA are necessary. That concludes my presentation, and I will now turn it over to Chair Lotta, and I would be happy to answer any questions members may have.
Thank you, Ms. O'Connor. Do I have any comments or questions from the committee members? Mr. Jacobson?
Thank you. You said that it's a new trend, and I believe that the materials say that it's a national trend. Is there, have we heard from, or do you know of any California or accountancy groups that are kind of pushing for this, advocating for it?
I have heard of some California firms that have transitioned to this model, yes.
Are they allowed to transition until without our putting something in place?
Yes, these particular firms were in compliance with the rules that they must follow for this type of model.
Thank you.
Mr. Franzella?
Thank you. And furthering on that, yes, they are in compliance with what exists today, and that's some of the questions being asked is, are the safeguards appropriate? Do changes need to be made to better protect consumers or make consumers more informed of the separation, because some are more clear in their separation than others and how they post on their website or solicit clients and the like. And I will say on a national level, when I was at the Western Regional with NASBA late last month, this was a significant topic for a number of the executive directors. ESOPs for some, because they don't have the flexibility within their statute to maybe accept those where California does. But the private equity group, they've had a couple of presentations from the SEC on this topic. And it's a big concern for a lot of the EDs, just ensuring that consumer protection is still being is paramount in licensing the entity that is still performing the services, and it's clear there's a distinction between who's doing what for those consumers.
Any other committee member comments? Ms. Chu?
Thank you, Chair. Um, do when the firm do change, make adjustment, are they are they obligated to inform CBA, or
So
as long as they're under the statute, they can just change? We
that's correct. However, they would need to provide an updated list of the shareholders to the CBA.
some touch point.
That requirement is for all CPA corporations. So they would just need to follow that regulation as any other corporation would have to.
Okay, so do we keep track of that changes at all? Or again, as long as they're under the rule, we don't have a separate data to track it? Because sounds like you do know that some firm have changed.
Yes, we don't have a tracking mechanism to track this particular change in their model.
And we are okay with that?
Mr. Franzella?
I can answer your second question first, and are we okay with that is up for you to decide. Are you okay with the present model, or does there need to be some discussion potentially nationally, which is occurring, but it's not, I think some of the states are trying to encourage NASBA, the UA, and the ICPA to maybe fast track this particular topic as well, because it's happening. And as for, I think the first part of your question, it really depends on what those touch points are. Some firms keep the same name even and operate under the same name, but maybe with LLC behind it versus something else. So it creates a level of confusion, whereas others separate that entity fairly clearly. Like they operate under one name. They might operate under two names, where it's clear one does the non-public accounting work and the other doesn't, or does the accounting work. And so there's more distinguishing characteristics. So it's very different from firm to firm. And as for whether or not we know, I mean, I don't know if necessarily know every private equity firm out there. So like when we get a list of non-licensee owners, which can be entities and not just natural persons, I wouldn't know if that firm is a private equity firm versus one that is just a just a potentially maybe a trust or a or something or some other corporation or entity. So I think there's room for improvement. I'm not saying that. I don't think anybody's saying that that private equity shouldn't be a part of the process, but there might just need to be better information available to consumers to identify them, maybe to understand the structures, to know what they're dealing with, and to make sure that there's just some increased consumer notice, I think, of what's going on in that environment. And just being, as we've talked about, and as Ms. O'Connor highlighted, there could be just some perceived risks with what private equity serves versus what a CPA firm serves in terms of public trust versus profit in some respects.
Ms. Thompson?
Are there any national reporting requirements for a PE-owned CPA firm to comply with, like any filings with the SEC or anything like that?
Not that I'm aware of, not to say that there aren't. I'm just not aware of that at this point, but I do know the SEC is looking at this particular topic. They actually provided a presentation. I believe NASBA worked with them to provide a presentation. I think they're doing another one here in August as they're looking at the topic. And I know the AICPA's peak. I never remember what PEEC stands for anymore, but their ethics compliance group is also looking at it. So we're just actually looking to maybe ask NASBA to also take an active role in this discussion from a state board of accountancy side of things.
I had one question in regards to independence. Do we have any specific examples in terms of the threats to independence that we think could be possible?
Yeah, one of the examples given was that the structure used by PE and the CPA firm is that employees are loaned or leased back to the PE back to the CPA firm. So that was a potential independence issue that was identified.
And my follow-up question is in regards to the letter that staff drafted. Do we think we should include more detail potentially? It seemed a little vague. I didn't know if we wanted to be a little bit more specific, just a thought. Or if the national conversation is developed enough that it provides enough direction to NASBA. Mr. Franzello?
I would say that's within the board's prerogative to add more if it feels there are examples it wants to have included. I think when staff were preparing this, and again, it's happening and it's being discussed. So there are things that are occurring, but staff are bringing this. We're at this kind of at a fact finding stage here as well, trying to understand what's going on, and in some respects, we're well positioned, but maybe not the best positioned group to identify all the potential issues and examples. And that's kind of why I think we're also trying to get NASBA into the dialogue as well. So I hesitate putting in too many examples, at least from staff's perspective. But if the board as a whole has specific examples it wants, we're happy to add those in. Just staff haven't really given that a ton of insight.
These two?
Yeah, so as long as this is like our first reading and it's gonna come back, it sounds like this issue will come back and we'll put more meat to the skeleton. Otherwise, I would assume being more broad at this point would make sense. But we'll keep an eye on it.
Okay. Do I have an emotion from the board members? Ms. Thompson?
I would like to motion to move forward with the letter to NASBA.
Do I have a second? Ms. Tu?
Can it?
Do we have any public comments here in Sacramento? Seeing none, moderator, please open the Q&A for public comment.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close the Q&A feature?
Yes, thank you, moderator. Ms. Reed, can you please take the vote?
Yin Tu,
Yes.
Teresa Thompson,
Yes.
Christian Lotta,
Yes.
Dan Jacobson,
Yes.
and Doug Aguilar.
Yes.
The motion carries.
Thank you. Moving on to agenda item number 4. Discussion and possible action regarding a process for accounting firm owners licensed with general accounting experience to obtain authority to sign reports on attest engagements. We have this presentation by Sarah Benedict, our manager of license renewal and continuing competency unit. I'll turn it over to you now.
Thank you, Chair Lotta. My name is Sarah Benedict, and I am the manager of the Renewal and Continuing Competency Unit. The purpose of this agenda item is to provide the CBA with an opportunity to review and discuss a possible pathway for CPA firm owners who are licensed with general accounting experience to gain the experience necessary to convert their license to one based on a test experience that would authorize the CPA to sign reports on attest engagements. The CBA's consideration of the Certified Public Accountant Experience Requirement Task Force, or CERT, recommended that staff explore a pathway to allow accounting firm owners licensed with general experience to obtain a test experience required for the ability to sign reports on attest engagements. Under the current law, a pathway for firm owners to convert their license to one with a test authority is not available because firm owners do not have a supervisor to review and evaluate the firm owner's work and complete the certificate of attest experience. At its January 2023 meeting, the CPA provided staff guidance on what the pathway should include, which is listed on page 2 of the agenda item. Staff sought input and guidance from Nazi Rayson, CPA, Enforcement Advisory Committee member, who also served as a Qualifications Committee member, Michael Williams, CPA, Qualifications Committee Chair, and Chris Smith, CPA, Qualifications Committee member, in the development of the proposed solution. Staff also sought input from Cal CPA, a CPA liability insurance provider, and NASBA. Staff presented a draft process to the CBA at its November 2023 meeting. The draft process required the applicant's firm to enter into a written agreement, such as an engagement letter, that allows for a third-party monitor to serve in a role like that of a supervisor. Additionally, the draft process required the applicant and the monitor to appear before the qualifications committee prior to granting the license conversion. The CBA directed staff to continue exploring the details of the draft process. Specifically, the CBA asked staff to provide safeguards to ensure that the monitor is knowledgeable and appropriate for the role, and to speak with interested parties to ensure that eligible CPAs would be willing to become monitors. To address the safeguards that ensure the monitor is knowledgeable and appropriate, staff added a requirement to the third-party monitor eligibility that they must have relevant experience in the applicant's specialized industry. To address the question regarding the willingness of CPAs to become monitors, staff met with Jeffrey DeLizer, CPA, partner at Prop Christensen Caniglia, LLP, and peer review oversight committee member Fausto Hinojosa, CPA, partner at Price Page and Company Accountancy Corporation. And we met with current peer review oversight committee. Fausto is the peer review oversight committee vice chair right now. Nasi Rayson CPA and Michael Williams CPA were also in attendance. I would like to extend my appreciation for the time and effort of Chair Williams, Ms. Rayson, Mr. Smith, Mr. DeLizer, and Mr. Hinojosa. The firm partners provided feedback, including the concern that firms would be less likely to take on the risk of monitoring if the monitor was required to be part of the engagement team and was held responsible for the engagements performed by the applicant. Following the meeting, the draft process was updated. The proposed process begins on page 4 of the agenda item. Attachment 5 provides a track changes version of the proposed process that was presented at the November 2023 CBA meeting. The key differences between the two are that there is an addition to the third-party monitor eligibility that requires the monitor to have relevant experience in the applicant's specialized industry. There's an addition to the engagement letter requirement that requires the applicant to track what portion of the engagement they worked on and the amount of time that the applicant spent planning, applying procedures, preparing work papers, and preparing and reporting on financial statements. The engagement letter no longer requires a third-party monitor to be part of the engagement team. Instead, the monitor must routinely meet with the applicant to track the applicant's obtainment of knowledge and hours worked on attest activities. The monitor is also responsible for opining on the quality of the applicant's work and whether it demonstrates satisfactory knowledge of current practice standards. I would like to point out that the proposed process does not include a requirement that the engagement letter be entered into prior to the applicant performing work on attest engagements. The proposed process only requires that the monitor obtain sufficient knowledge of the applicant's knowledge and ability. Staff do not have a recommendation on this item. Staff believe that the proposed process places as many limitations on the monitor-applicant relationship as possible without making the process so cumbersome that potential monitors do not wish to engage with applicants. The CBA may wish to consider if the proposed process provides sufficient consumer protection and if the process for firm owners with general accounting experience to obtain the experience necessary to obtain authority to sign reports on test engagements is feasible. If the CBA approves the proposed process, staff will begin working with legal counsel on the promulgation of regulations. That concludes my presentation. I will now turn it over to Chair Lotta, and I'm happy to answer any questions that members may have.
Thank you, Ms. Benedict. Any comments or questions? Mr. Aguilera?
Thanks for the presentation and all your hard work and getting the committees together for the informal information groups together. I'd like to see an arrangement letter. I've always liked to see an arrangement letter, but I don't know if we can make that mandatory or not. Just I would vote for it so that there's a clear understanding between the monitor and the licensee as to what the relationship is and especially the payment terms as well, which leads me to my second comment about the payment amount. You know, there's going to, if there's a payment, there's going to be some tension between what you might say the consultant and client. If I'm getting paid a substantial amount, I might be, you know, I might tend to let some things slide that I normally wouldn't if I were a regulator. But that same tension exists today with the accounting firms and their clients. The third thing is the Enforcement Advisory Committee had a member who was a former PCAOB employee, and he created his own consulting firm, and they consult audit firms on how to stay in compliance with the PCAOB and how to mitigate any findings or to help them come into compliance. And thinking about that firm, for example, if they were willing to add this to their practice line, they're good candidates to evaluate the applicant's activities and the quality of their work. They might be interested in becoming one of, say, a few registered firms that the CBA agrees are qualified. You know, if they say that the requirements have been met, then we say that they've been met. A little bit like education providers. So Cal CPA or Becker, we recognize them as or maybe their courses as being approved. If you pass those courses, we accept their results. Or thank you.
Thank you. Ms. Benedict, do you have a response?
I just wanted to point out that the current procedure does not require the CBA to pre-approve monitors. Are you asking that we consider adding that to the process?
I guess if we had a couple of firms that we relied on, so we sort of pre-approve the firms and then accept their results without question. The other thing I'm thinking about is trying to develop some supply. You know, if these firms knew that they were going to get a larger volume of business or that they could turn this into a line of business, they might be more motivated to help in this process.
Thank you for the clarification.
Yeah, I think Mr. Aguilera raises a good point. Perhaps that pre-approval process would eliminate the necessity for the QC review at the end of the process. It could be a potential other alternate pathway that we consider. Did our committee members have any additional comments? Mr. Jacobson?
Thank you. Just in about the concept, it seems like it's wrong to not allow these people to to qualify to be test services because of the professional position in which they seem to fall. So I'm for moving forward with the process.
Ms. Tu, were you next?
Yes. So, do you think, I mean, between Mr. Argala and yourself, do you think there is enough firm? Because obviously, if there's a pre-approval process, we don't want only one or two firm. We want to have enough that consumer can choose from. Is there enough out there to do that?
So yeah, exactly. So that's the question that I was trying to address is how do we get enough monitors? Because I think it's going to be very challenging to get monitors. This doesn't sound very enticing to me. It seems like it's full of risk and it's a burden and not very enticing. So if it becomes a business proposition where I can turn a profit, I might be more interested.
Ms. Thompson?
Um, just to express sort of another point of view, I have some concerns around the idea of pre-approving monitors just because of the administrative burden that it would result on possibly the board and the department. And I think it creates an undue barrier to entry for monitors, especially if we think of smaller local sole proprietor CPAs who might need a monitor in the short term or to cover a probationary period. Um, it just, my reaction to that is that we might be actually creating more of a barrier than would benefit our ultimate objective.
Thanks. Now I realize what the confusion is that anyone can still be a monitor is the idea. But if there were firms that wanted to go through this process, so it would be a burden on staff one time, then we could note that, you know, these firms are accepted and available, but you don't have to choose them. You can go out on your own and find a monitor who follows, who meets our guidelines, use them, and we'll accept the results as long as we understand what happened and we approve it.
Ms. Benedict or Ms. Center?
Thank you for the feedback. This has been particularly challenging as we really look at balancing consumer protection, ease of administration on our part, as well as, you know, trying to make something enticing, as you mentioned. We want there to be monitors if individuals seek them. So it has been very challenging. I do want to point out that, you know, if we decide we want to go this pre-approval route, staff would need some time to consult with legal counsel. That may require a legislative change. I'm not sure. So just provide us with that time to go back and seek that guidance if that is the motion you decide to take.
I think the first piece of information is, are there companies out there that would be interested in this? It could be that there aren't any, so it's a moot point.
I had a follow-up question, Ms. Center. In regards to a pre-approval process and potentially maybe that replacing an appearance before the QC at the end of the process, in terms of administrative burden on staff, do you have an idea of like which would be more?
Really, it's hard to estimate because we don't know how many individuals are interested in this. If we do a pre-approval process, we're going to need to develop an open process whereby anyone could apply. We would have to evaluate them. That is quite a bit of staff work. If we only get one response, you still have all of the work to develop the process in there, even though you don't have as much review on the end. But as Mr. Aguilar mentioned, we don't have a good sense of who's out there. We do know that at least one individual indicated that it might be something that she would see maybe firms particularly that work in the tax area doing at times of year when they are less busy. Though I hear tax season is year round now, so I don't know. But that was one comment that was made. We could do a request to see who's interested. I don't know how effective it would be because it's so vague right now to describe to someone to see if there would be an interest. So I think that's the trouble that we're having. Like, are you interested in this with kind of this outline? It's like, I don't know. Of particular concern when we spoke to the two individuals with firms was really a concern with risk and wanting to ensure that they have a way to minimize that risk. And we did have a conversation with Chemico who indicated that they thought that we put in enough safeguards where that it would fall within normal policies that they have with their clients. But that being said, it is a very unique relationship. You can see why we did not put a specific recommendation in this item.
Mr. Franzella?
Sorry, I was actually just,
Oh.
but on that,
Sorry.
on that point though, I think, as Ms. Sinners alluded to, and I think it's been clear, there's an issue that we have with individuals needing this opportunity. The question, and I think there's a supply of those individuals. The question is, will we have the other side of the equation with the people willing to provide the oversight and monitoring? And while I normally wouldn't advocate one way or the other, it does feel like putting something in place, even if including this particular option, would give the board an opportunity to see uh, if individuals are willing to take it up. Because ultimately, I don't know if we're going to ever be able to solve are there firms until we actually have something that was in place and they were willing to evaluate it and make assessments. Because at this point, it feels like we can continue to refine this and it'll be a moving target the entire time to try to find something that might get so narrow that nobody's going to want to. We'll have a huge supply of individuals who want to take advantage of it, but no firms to do it. So I think staff have brought it back. This point is we've workshopped this to, I think, its fullest kind of form here. And it doesn't mean that as we implement it or as it evolves over time, that it can't evolve to something that has a pre-approval process, because we only see a handful of firms doing this and it kind of can migrate to that, or it needs to evolve to have a specific type of engagement letter. I think there can be an iterative process, but I do believe if the board really is serious about wanting to address this, we probably need to do something in this form, because I think staff have workshopped it to the point of kind of giving a good landing spot for the time being.
Ms. Tu?
And also with the process of pre-approval, I'm not sure if I would want us to get into that business because of the liability possibilities. I mean, and Mrs. Center mentioned already that she would need, we would need to go through legal process, and I have a hard time willing to uh, sign on to something like that, because just the risk, and potentially we as a organization and a firm, to pre-approve a firm could put ourselves in liability as well if something goes wrong.
Mr. Aguilera?
I just want to note about the risk mitigation. If there isn't, for the monitor, the engagement letter is helpful. It doesn't mitigate the risk, doesn't mean that they won't be sued, but if there's an engagement letter, they have an opportunity to put in the hold harmless and limitation of liability clauses.
Thank you. I did have a couple of questions myself in attachment 5, under the third-party attest monitor eligibility section. For bullet point 2, it reads, monitor or the monitor's firm must have a current pass rating on their most recent peer review at the time the engagement letter is signed. This verbiage was stricken out and must maintain a pass status during the life of the engagement letter. And it was replaced with if the monitor or the monitor's firm does not maintain a peer review pass status during the period covered by the engagement letter, the qualifications committee will consider the peer review findings and how those findings may have impacted the monitor's role. I wanted to know what was the reason for that verbiage change?
The reason for that is because sometimes people may get a pass with deficiencies and it may be more of a minor deficiency. And so we may not want to disqualify that monitor on something that the qualifications committee doesn't consider like an egregious act. So we just tried to broaden it a little bit.
Ms. Center, did you have a follow-up?
We also wanted to make sure that this agreement is going to go over time. And so we didn't want to disadvantage the applicant whereby they did have a pass when they went into this agreement. And then during the life of their agreement, they got a pass with deficiency, right? And so we wanted to not automatically disqualify them and yank that monitor out, but have a time to evaluate, like Sarah said, sometimes these deficiencies are really not about technical areas. And so because of that, we may determine it to continue to be appropriate.
Thank you for that clarity. I understand the reasoning for when it's minor deficiencies, but in the case where that's not the case and it is an egregious um, failure, does this expose the applicant firm to a greater risk of inadvertently engaging with an unqualified monitor if, after the fact, when they do appear before the QC, it does turn out that that does prohibit the monitor's ability to do their job appropriately?
There is a level of risk for the applicants who engage in this process because we do intend to bring them before the QC, and the QC is really going to ask this monitor questions about, for example, if there was a finding on peer review, we would ask about that finding. We would ask questions about how they went about monitoring the applicant. How many times did they meet? What were those conversations? What was the recording of time? All of those kinds of questions pose a risk that the QC may not be satisfied and may result in us, the staff, recommending a denial of the conversion. So there's always that risk, but that risk is inherent with any application. So it is no different than any other application process.
And have we thought through in the case where this happens, where you appear before the QC and there was a failure for the monitor and it was egregious, it would just be a denial, or have we thought through the process after that for the applicant or the steps they can take?
So when we have individuals appear before the QC, we take that information from the QC and then we, board staff, respond to the applicant, right? So sometimes we are able to provide the applicant with detailed information. So for example, they didn't think the hours and experience in this particular category was sufficient. That provides them actionable information to go back. The feedback could be that specific. It could be more broad, depending on if it was a monitor that wasn't sufficiently monitoring. So we would look to provide something similar to what we do now so that they don't just get a denial, but there's actionable information, if appropriate, that they can go back and take.
Thank you, Ms. Center. And then I had a question on the fourth bullet down. When it's saying that the monitor firm needs to have at least 4 of 10 years preceding the engagement letter in a test experience. What was the reasoning from reducing to 4 versus 5 years?
As we go into a regulatory process, we always need to be able to come up with justification for the number of years. We already use 4 of 10 for many different decisions at the board. Based on reciprocity, based on practice privilege. So because of that, we thought we would have a better justification for 4 of 10 than 5 of 10.
Thank you. Any other comments, questions from the committee? Seeing none, any public comment here in Sacramento? Let me back up. Do I have a motion from the committee members? Mr. Jacobson.
I I move that we direct staff to move forward on this issue and to come back to us with a finalized program, taking into account uh, the comments that have been made today.
Mr. Franzella?
You need a second.
Oh, okay. Ms. Two, do I have a second?
I second it.
Thank you. Mr. Franzella?
And just to be clear, Mr. Jacobson, you're wanting us to come back and conceive of this in a regulatory package or taking that step, not because the proposals here, you want us to take the next step to like form it out into a regulation and what that would look like for the board to consider and adopt.
Yes.
Okay.
Mr. Aguilera?
Is that what you were looking for, is approval to go and start drafting regulations? Thank you.
Okay, and Ms. Two, you are in agreement with the clarification on the motion? Okay. Do I have any public comments here in Sacramento? Seeing none, moderator, please open Q&A for public comment.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, thank you, moderator. Ms. Reed, please take the vote.
Doug Aguilera,
Yes. approved.
Dan Jacobson,
Yes.
Christian Lotta,
Yes.
Teresa Thompson,
Yes.
and Yin Tu.
Yes.
The motion carries.
Thank you, Ms. Reed. That concludes our Committee on Professional Conduct meeting today. Meeting is adjourned.
Legislation committee will start in 5 minutes.